Okay, I am calling 23-45559, estate of Arlie R. Horn Jr. Can I get announcements of council?
Your Honor, Randall Perrier here for the move-in.
Your Honor, Ted Segal here on behalf of Nick Dupree, for Nick Dupree on behalf of the beneficiaries.
Okay, Mr. Perrier, would you like to present your motion?
Sure. I'm here. I'm counsel for movement Irina Horn, the duly appointed independent executor for the estate of Arlie R. Horn Jr. She was appointed as the executor about November 16th, 2023. And we filed a motion here today to remove and have expunged a notice of lis pendens that was filed by the beneficiaries of the estate, Amanda Beringer, Emma Wheeler, and Eli Horn. This notice of lis pendens is procedurally defective and legally defective and should be expunged pursuant to Texas Property Code 12.0071. And it's causing harm to the estate because it's encumbering some real property. If I may, I'd like to share my screen. I can just share out a provision of the property code with the court. Under section 12.007A paren A, 12.007 paren A, a lis pendens is only valid if it is filed for an action involving a title to real property, or the establishment of an interest in real property, or the enforcement of an encumbrance against real property. And that's the reason you would file a lis pendens. The beneficiaries who filed their lis pendens in this case have filed it in relationship to their motion to remove the executor and to compel an accounting, which has nothing to do with claims related to title or ownership of property. Instead, their pleadings address administrative concerns such as mismanagement of the estate or an accounting, which do not impact title. Of course, as this court knows, you cannot demand an accounting until the executor has been appointed for more than 15 months as the executor. That notwithstanding, under this statute, once you have filed a lis pendens, subsection D here says that 3 days after a lis pendens has been filed, a party filing a lis pendens must provide notice of that lis pendens to the persons who have an interest in the real property or affected by this notice. I would point out to the court the history of this statute is on the next page here. This became effective, I don't know if you can see this on your screen, September 1, 2009. And so the September 1, 2009 is when that paren D became effective. And so when the court looks at sites and authority that predate 2009, the court would maybe misled to think that that constructive notice by just filing in the county record with the county clerk would be sufficient with the lis pendens, but this is a new provision effective after 2009. And then I'll take you to the next section, which is the other provision that was made effective in 2009, which is the section that governs the motion to expunge a lis pendens. And this provides that the court will order a lis pendens to be expunged if a pleading on which the notice is based does not contain a real property claim. That's what we are dealing with here when the pleadings involved in this dispute are the beneficiary's claim to remove the executor and to demand an accounting and making allegations against my client as the executor. The lis pendens can also be expunged if the court finds that their claims lack the viability as a real property claim by a standard of evidence. And finally, a significant issue here is the court can remove and expunge a lis pendens if the person who filed the notice for record did not serve a copy of the notice on each party entitled to a copy under section 12.007 paren D. So that's that provision we just covered that requires the notice be served within 3 days after filing the lis pendens. And I'm going to share with this court the affidavit that was filed in this proceeding. I'd like to offer this. First of all, I'd just like to ask the court to take judicial notice that this has been filed in the court's record, which is an affidavit of no record of no notice.
Okay, what am I taking judicial notice of specifically?
That this affidavit of no notice has been filed in this record. It's been filed in this proceeding.
Any
It's
objection?
already. I'm sorry. Go ahead, Your Honor.
I need you to answer out loud, Mr. Seago.
No objection, Your Honor. Sorry, I didn't want to interrupt you. I thought you were going to ask me again.
No, it's okay. Thank you. Judicial notice is so taken.
Yeah, in the alternative, we also offered this as movement exhibit number 2.
What is this? This
affidavit of no notice.
Okay, have you sent that to Martha?
This was filed to each of the parties yesterday.
So for Zoom hearings pursuant to standing order, you're supposed to email exhibits prior to the hearing, so we have them.
Oh, Your Honor, I failed to do that.
All right, Mr. Seago, do you have a response?
Just briefly, Your Honor, I think there's two kind of main issues here is whether the lis pendens involves real property in the notice, and I'm going to address the involvement of real property first, if that's all right with you, Your Honor. Yes. So, Your Honor, as we've already talked about, this matter ultimately comes from a beneficiary and a trustee dispute, and the beneficiaries filed this notice of lis pendens because the real property located that we've been talking about today, but located at 457 Edgewood Drive, Montgomery, Texas, is a central asset of the estate. And there are ongoing disputes concerning its management, administration, and eventually the potential sale. So the lis pendens was properly filed under Texas Property Code 712.007A to notify third parties that the property is subject to the pending probate dispute, ensuring that it remains available to and for proper estate administration in the attempt that it was going to be sold. And so this was to protect the beneficiary's right in the real property at issue. Now, the movement now seeks to expunge the notice because there's allegedly failed to meet the burden. But the law is clear. It involves the claim of the lawsuit involves a claim affecting real property, and that property is the central part of the estate that we're here to talk about ultimately today. And whether or not the case that was cited in the response, which was In re Collins, was that was a 2000. I just had it up. I'm sorry. It was a 2005 case, Your Honor. But that case was followed up by In re J Cohen, and that site is 304 S.W.3D889. That was followed up by, like I said, In re J Cohen, and the holding is the exact same, Your Honor, is that properly filed lis pendens is not in itself a lien, but rather it operates as a constructive notice to the world of its contents.
Okay, and then do you want to address the procedural aspect?
The procedural aspect being the constructive notice, Your Honor, or just the...
Oh, you said you were going to respond to the two different arguments, and you would start, I thought that was all the same argument. So that's all of your argument?
Yes, ma'am. The first argument being that it affects real property because the estate is the one, or the property is in the estate, and that's what we're here to talk about. And then that even if the case, which was In re Cohen, which was cited in the response, was 2005, and counsel pointed to a statute that went in effect in 2009, we have a lot of case law that comes after, and specifically the one that I put on the record that says the exact same thing, that a lis pendens files as that addresses that procedural issue, Your Honor.
Okay. Anything further, Mr. Perrier?
Yes, Your Honor. The The will in this case, I asked the court to take judicial notice of the will that's been admitted in this case for Arlie Horn.
Any objections?
Your Honor, I don't know if that's, I don't know if that was an exhibit to the motion that we're here to talk about today or not. So, Your Honor, I guess I do have an objection just because I don't understand the relevancy to today's motion.
What's the relevance?
Well, the will in question provides that the decedent, that the property in question is specifically devised to the movement. So the allegations in beneficiary's motion is that the subject property is that they're concerned about its management. The subject property is specifically devised to Mrs. Horn, and so its management is not up for dispute. It doesn't matter who is serving as executor or what is going on. This property is going to my client, and so a lis pendens only serves to impair my client's ability to operate as the executor and to convey this property to herself in conformance with the terms of the will. And so the lis pendens actually serves no benefit to any of the beneficiaries. All it serves is to interfere with her ability to operate as the executor. And so going further, the case law governing lis pendens require under Texas law that the lis pendens serve, there must be an adequate nexus between the lis pendens that is filed and the subject property. Here, the lis pendens that's been filed there's no nexus to this property and the claims that the beneficiaries have filed. They're asserting that these claims that there's problems with the way the Mrs. Horn has been administering the estate. That has no nexus to the property which she's entitled to under the terms of the will, irrespective of her management of the property. So as they've described in their own response to the motion to expunge the lis pendens, they want to make sure that this property remains in the estate so it can serve as a asset that they could seek as a judgment, a source of satisfying a judgment if they find a satisfaction in pursuing her, not as a way of having any entitlement to this property at the end of this estate. So this is not as a lis pendens is designed, an interest to preserve their right in an asset, to preserve the right in real property, to create an interest in real property, or in an encumbrance in real property. None of that is what this lis pendens was filed for.
All right. So is that everything we have on this motion?
Well, the primary issue here is that, Your Honor, under case law, you have to consider whether their claims are collateral matters or directly related to the real estate. The matters that they have provided that they are seeking are collateral to the property in question, not directly related to real estate.
Just very,
that's all we have.
Mr. Segal?
So, Your Honor, in the case that we cited in our response, the Ray Collins case, Your Honor, at the end of page 294 and the beginning of 295, the court says, we hold that when the motion, which is a motion to expunge, challenges the pleading supporting the lis pendens, the trial court should examine the pleadings to determine whether the pleader has alleged facts that affirmatively demonstrate that the lis pendens is proper. And by proper, they mean tied to and alleging enough facts to, like opposing counsel said, create that nexus between the property and the lis pendens yourself. Your Honor, the entire claim that's being brought by the beneficiaries is that the executor is mismanaging the estate, and whether or not the executor is going to end up with a property or not, this is the only way that they can protect the estate from further mismanagement to ensure that the house, and which is a part of the estate, whether or not it's going to go to the executor or not in the end, is being kept in the estate and part of all of part of their interests to ensure that the mismanagement doesn't continue or doesn't apply to their detriment. We're not asking to have the lis pendens forever, Your Honor, but just at least until the court either decides or we go to trial on the issue of whether there was mismanagement.
I'm going to take it under advisement, take a look at those cases, and I'll get y'all a ruling quickly by the end of the week, definitely.
Thank you, Your Honor.